Hello and welcome to the Minimum Competence episode for Tuesday, March 31st, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, DOL rule opening retirement plans to crypto, an FTC privacy settlement with OkCupid, and my take on Georgia's gas tax holiday. Spoiler alert, it's a terrible idea. Let's remember, the earth laughs and flowers, and read today's legal news. On this day in legal history, March 31st, 1949, the Dominion of Newfoundland officially entered Confederation, becoming Canada's 10th province under the terms negotiated with the Government of Canada. This union followed a series of national referendums in Newfoundland, where voters ultimately chose Confederation over alternatives such as responsible government or economic union with the United States. The legal foundation for this transition was established through the British North America Act of 1949, which amended Canada's constitutional framework to admit Newfoundland as a province. These terms of union set out the division of powers, financial arrangements, and transitional provisions necessary to integrate Newfoundland into the Canadian Federation. One key legal issue involved the assumption of Newfoundland's public debt by Canada, which required careful fiscal and statutory planning to ensure a smooth transition. The agreement also guaranteed certain social benefits, including family allowances, aligning Newfoundland residents with federal welfare programs already in place across the rest of Canada. Additionally, the terms address transportation links, committing Canada to maintaining ferry services and improving infrastructure between Newfoundland and the mainland. Legal provisions were also made for the continuation of Newfoundland's existing laws until they could be harmonized with Canadian federal and provincial statutes. The union raised constitutional questions about federalism, particularly how a previously self-governing dominion would adapt to a provincial role within Canada's system. It also required coordination between British and Canadian authorities, as Newfoundland had been under direct British administration prior to Confederation. The involvement of British Parliament underscored the imperial legal framework still governing such transitions at the time. Over time, Newfoundland's legal system was gradually aligned with Canadian norms, though some regional distinctions persisted. This event illustrates the complexity of constitutional amendment and territorial integration within a federal system, particularly when sovereignty is partially transferred. It highlights how legal agreements can structure not only governance, but also economic and social policy for newly incorporated regions. The terms of union remain a foundational legal document in Newfoundland and Labrador's relationship with Canada to this day. The U.S. Department of Labor has proposed a rule that would expand access to alternative investments in retirement plans, but the shift raises some real concerns, especially because it opens the door to assets like cryptocurrency. Framed as a clarification of fiduciary duties under the Employee Retirement Income Security Act, or ERISA, the proposal creates a safe harbor process that makes it easier for plan managers to justify including complex and higher risk investments. At its core, the rule emphasizes that fiduciary responsibility is about process, not outcomes. That means as long as plan fiduciaries can show they considered factors like performance, fees, liquidity, valuation, and complexity, their decisions may be presumed prudent, even if the investments themselves are volatile or difficult to value. The proposal also reinforces that no category of investment is off limits, explicitly rejecting any per se restrictions. That neutrality is doing a lot of work. In practice, it signals that assets like private equity and notably digital assets such as crypto can now be more comfortably included in 401k-style plans. Supporters argue this expands diversification and potential returns, but the trade-offs are significant. Many of these alternative assets are less transparent, harder to price, and more illiquid than traditional investments, risks that are especially concerning in retirement accounts designed for long-term stability. Crypto, in particular, introduces extreme volatility and regulatory uncertainty, which may sit uneasily with ERISA's protective purpose. The rule also appears designed to curb the rise in fiduciary litigation by giving courts a reason to defer to plan managers who follow the outlined process. While that may reduce frivolous lawsuits, it could also make it harder for participants to challenge genuinely risky or poorly performing investment choices. In effect, the proposal shifts the balance. It gives fiduciaries more flexibility and legal cover, but potentially at the cost of exposing retirement savers to more complex and speculative assets. The big question is whether procedural compliance should be enough when the underlying investments themselves may carry substantial and unfamiliar risks. Match Group has agreed to settle a lawsuit brought by the Federal Trade Commission over allegations that its OkCupid platform improperly shared user data. According to regulators, the company allowed a third party, Clarify, to access sensitive information from millions of users in 2014 without proper disclosure. This data reportedly included photos, demographic details, and location information, despite privacy policies suggesting otherwise. Under the settlement, Match Group is barred from misrepresenting how it handles user data and must implement compliance measures to ensure its privacy practices align with its public statements. The company did not admit liability as part of the agreement, but could face financial penalties if it violates the terms in the future. The settlement still requires court approval. OkCupid stated it has since improved its privacy protections and that the conduct at issue does not reflect its current practices. In my column for Bloomberg this week, I argued that Georgia's gas tax holiday is poorly timed, arriving not during a routine price increase, but at the onset of a global war-driven supply shock. While the policy may appear to offer immediate relief at the pump, I explained that higher prices actually play a necessary role in a market economy by signaling scarcity and pushing consumers to reduce demand. By lowering gas prices artificially, the state disrupts that signal, encouraging more consumption when conservation is most needed. I point out that this kind of intervention weakens the natural coordination between supply and demand, keeping consumption higher than the market can sustain, and ultimately prolonging the imbalance. Rather than solving the problem, it risks shifting it into the future in the form of tighter supplies or even shortages. I also note that policies like this are politically attractive because they are visible and easy to implement, but that same visibility effectively subsidizes fuel use at the worst possible moment. Drawing on the experience of the 1970s energy crisis, I argue that similar efforts to shield consumers from rising prices led to distortions, long lines, and delayed adjustment rather than lasting relief. I describe the gas tax holiday as affordability theater, giving the illusion of help while masking the underlying scarcity and potentially leading to higher costs later. At the same time, I highlight how broader policy choices are working against long-term solutions by discouraging alternative energy sources and making substitutes like electric vehicles less accessible. I acknowledge that rising gas prices create hardship, especially for lower and middle-income households, but I argue that relief should be targeted and delivered through mechanisms like refundable tax credits or commuter benefits. This approach would help households manage costs without incentivizing additional fuel consumption. I also emphasize the need for policies that actively reduce demand, such as investing in public transit, encouraging remote work, and promoting conservation. Finally, I argue that any revenue gains from higher prices should be used to strengthen infrastructure and energy resilience rather than just mask our current problems. I conclude that while supply shocks inevitably bring economic pain, delaying adjustment through misguided policies will only make the consequences more severe in the long run. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. If you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, no winter lasts forever, no spring skips its turn.